Mga kababayan, ang pambansang awit ng Pilipinas.
Kayang mag-ibig, telas ng sinananan, alam ng puso, sa dikit mo'y buhay. Lupang hinirang, kuya ka ng magiting, sa mandulupin, di ka pasisigil, sa nagatang tutok sa simoy at sa langit mong pagaw, ay hinatang tulad, awit sa paglayang minamahal. Ang isang ng matawad mo'y tagumpay na nagtitindig, ang bituin at araw niya kailan pa may di magtitindig. Luma ng araw ng walhaging pagsinta, buhay langit sa piling mo. Ang inigaya na pagkay mga amin, ang mamatay ng dahil sa'yo.
Welcome remarks, Nisa.
Okay, thank you very much. Now we will maybe call on the Director of the AFP Center for Law of Armed Conflict, Brigadier General Joel Alejandro S. Naknak, Philippine Army, for the welcome remarks. Sir?
Sorry for the inconvenience, because we are on travel and we have just came from the Ranger Regiment. We are on our way to Manila, but we had difficulty on our signal. But nevertheless, let me proceed with our part on the welcome remarks. Pope Benedict XVI once said, and I quote, "Every state has the primary duty to protect its own population from grave and sustained violations of human rights, as well as from consequences of humanitarian crisis, whether natural or man-made." End of quote. Being with a uniform service and as the security forces in our country and government, we have seen atrocities committed by non-state armed groups, particularly the communist terrorists against our Filipino citizens, our fellow Filipinos. Indeed, we are compelled to take action to protect our people from these violations of human rights and international humanitarian law. But before I proceed, let me first greet and find this opportunity to greet, of course, Lieutenant General Ferdinand M. Bocobo, PMAAI Foundation for Truth and Justice Incorporated. Good afternoon, sir. Other senior cavaliers online, our honored guests and speakers, namely Ms. Georgia Hines, the Regional Legal Advisor of the International Committee of the Red Cross, or ICRC, Delegate, and Military Program Manager of the ICRC in the Philippines. Officers and members of the PMAAI, also the officers and members of the PMAAI Foundation for Truth and Justice Incorporated, the members of the AFP Center for Law of Armed Conflict, and of course the different human rights officers of the AFP who are online today. Good afternoon. It is my privilege to inform you that we especially, for those who just came in, and we are now on the second installment of our legal Law and Law of Armed Conflict webinar series for this year 2021. For those who just joined us here, the first webinar tackled human rights as well as the Commission on Human Rights functions, duties, and responsibilities. Now, in the second webinar, we will talk about international humanitarian law at the local scene, the regional, as well as the international or global context. In our first webinar, we had experts from the Commission of Human Rights. And today, we will have our experts also from the will give us a full-rounded approach on or backgrounder of the international, regional, and as well as the local point of view. At this point, I would like to thank PMAAA Foundation for Truth and Justice Incorporated and the PMA Alumni Association for embarking with us, the AFP Center for Law of Armed Conflict, on this joint project to conduct series of webinars and trainings for all our members as well as to the members of the uniformed services. This webinar series aims to educate us and promote, update our participants in the area of international humanitarian law. For next round, we will have the anti-terrorism law as a subject. Our attendees today, today's seminar came from different backgrounds. We have PMAAA members, armed forces, as well as other uniformed services personnel, officers, and of course, the delegation from our office. It is therefore my esteemed honor and privilege to welcome all of you in today's activity. I hope that we will learn a lot from this series of webinars, especially that we have with us experts from this field of study on international humanitarian law. Good day, and let's enjoy this series. Thank you.
Thank you, Brigadier General Naknak, sir, for the welcome remarks. Now we will go and proceed with our lecture proper. And at this point, let me introduce to you our first speaker. Our first speaker is the head of the legal department and of the International Committee of the Red Cross in the Philippines, and she is Miss Georgia Hines. Miss Georgia is the head of the legal department for the ICRC in the Philippines. She previously served as the regional legal advisor for the ICRC in the Pacific, based in Australia and covering 16 countries across the region. Prior to joining the ICRC, Georgia worked in the Office of the International Law Australian Attorney General's Department, advising the Australian government on public international law, including international humanitarian law and human rights law, and international criminal law. She practiced as a solicitor in commercial law in Brisbane, Sydney, and in Singapore, and has also served as a service officer with the Australian Army. Georgia holds a Master of Laws in International Law with distinction from the Australian National University, a Bachelor of Laws, Hons, and a Bachelor of Arts from Griffith University, and is admitted as a solicitor of the Supreme Court of Queensland and the High Court of Australia. Ladies and gentlemen, Ms. Georgia Hines.
Thank you, Lieutenant Colonel Esquivius, for that very kind introduction. And I'd just like to say how impressed I am with the resourcefulness of you all coming in live whilst traveling. It's an excellent example of multitasking and adaptation in difficult circumstances. So very well done. And I'd also like to acknowledge Brigadier General Naknak and the other senior members of the Centre for the Law of Armed Conflict, and of course senior members of the PMAAA as well. Now I do have a PowerPoint just so that you have a bit of visual stimulation. Let me see if I can share it. Please tell me if you can see this.
We can see it, ma'am.
Excellent. All right, great. So as Brigadier General Nak alluded to, we'll be covering, I think today, various aspects of IHL, from the global to the regional to the local. So my presentation will focus on that global aspect, and in particular, looking at some of the key challenges that the ICRC has identified when it comes to IHL, its implementation, and perhaps areas for development as well. So moving to my first slide. So every 4 years, the ICRC publishes a report, and it's called the Contemporary Challenges Report. And this does exactly what I've just said. It sets out what we see as the headline contemporary challenges that we sort of forecast. It's a bit of a horizon scanning exercise. So the last one was done in 2019, and it covered some of the areas that you can see on your screen. I won't be going through all of these today because we have very limited time, but maybe in the Q&A, if there's anything that comes up that we haven't addressed, I'd be happy to take it there. So today, what I'll be looking at are just a very high-level overview of these particular topics, and I'll move through each of them in a bit more detail. So the first one that I wanted to talk to you about is the urbanization of warfare. I think it's fairly obvious that as the world becomes increasingly urbanized, so does conflict, and the ICRC sees fighting more and more in urban areas. And the thing is that it's civilians here that bear the brunt. So even if civilian services aren't directly targeted, they're often disrupted, and that's as an indirect result of attacks. So you have inhabitants left without food, without water, sanitation, electricity, or deprived of healthcare with interruption to services. In addition, we see fighting in urban centres resulting in widespread displacement, and even after the fighting stops, those who are displaced often are prevented from coming back due to the presence of, say, unexploded ordnance or other weapon contamination, or an ongoing lack of basic services that they need. And I should say that many of these consequences are, of course, they're not unique to cities, but they do occur on a much larger scale in cities in urban warfare. Urban warfare also, in addition to these humanitarian consequences, it raises some interesting questions about how we interpret and apply relevant IHL rules. So I'm sure you'd all be aware we have the concept of incidental civilian harm in IHL. Now, when you look at the complexity, the interconnectedness of essential service systems, it makes it particularly important that we consider not only incidental harm directly caused by an attack, but also what is known as foreseeable reverberating effects. And I think this is similar to what you might know of as second or third order effects. So of course, you'll have the direct effects. You'll have deaths, injuries, damage to buildings, but then there are also things like damage to health, water, electrical facilities, and these will have serious flow-on consequences for a much larger part of the population. And these patterns of incidental civilian harm obviously will vary depending on the circumstances, but they can be foreseen based on the past experience of the effects of urban warfare. And so it's really important that armed forces are applying very short feedback loops and other lessons learned processes as part of the targeting cycle or other decision-making processes to prevent those same mistakes and to inform future assessments of effects. Urban warfare also has a challenge in relation to the application of proportionality, because you have many objects that are used not only for military, but also for civilian purposes. So for example, very common, you might have a firing position on top of a civilian house. You might have one apartment in a complex that's used as a command post. Or very commonly, you'll have a power station that provides electricity both to a military barracks, but also to the rest of the city. So these military uses could absolutely render the object a lawful target. That's beyond question. But then how do we calculate proportionality? Does the whole apartment building become a legitimate target, or do you have to factor in the damage to the other apartments in your proportionality or your collateral damage estimate? How do you factor in the loss of functionality of the power station to the civilian supply as incidental civilian harm? So the prevailing view, and the one shared by the ICRC, is that these kinds of consequences for civilians of damaging or impairing the civilian use of the object do have to be factored in. So they're just some of the IHL implications of urban warfare, but we can talk about that later if you're interested. The next challenge I wanted to highlight is in relation to one of the many needs of civilian populations that we see, particularly in protracted armed conflicts, and that is access to education. Because very often what we see is education being disrupted during armed conflict. And this can happen for a variety of reasons. So it can be that the students or the teachers or the infrastructure is directly targeted or incidentally harmed in an attack. But you might also have military use of education facilities that can impede learning, and it can expose the school to attack by the enemy. You might also have armed forces or armed groups recruiting children or committing acts of sexual violence against them in or near schools, which obviously means that children are less likely to attend schools. And schools are often closed by the authorities due to security concerns in conflict areas. So under IHL, schools don't have special protection. They're protected as civilian objects in the same way that students and teachers are protected as civilians, unless they participate in hostilities. And so the only way that a school can be targeted is if it's turned into a military objective. Now, to minimise the risk of this, of a school becoming considered a military objective, militaries should be very carefully assessing the use of or any presence by them in schools. And then, of course, even if the school does become a military objective, the party attacking still needs to run through all those IHL principles in attack. They need to take precautions to avoid incidental civilian harm, and they need to go through distinction, proportionality, all those things that are built into the targeting cycle. Now, moving on, so new technologies in war. I think this is often one that gets a bit of the imagination going in some areas. So I think it's fair to say that many states are investing heavily in developing means and methods of warfare that rely on digital technology. So you have cyber tools, you have increasingly autonomous weapon systems, artificial intelligence. They're all already being used in current armed conflicts. So for the ICRC, we follow these developments, including participating as an observer in various UN processes that are going on in relation to cyber and autonomous weapons. And I really want to be clear, our aim is not to ban these technologies. In fact, we actually recognise that some of these advances can produce better outcomes for civilians. You might have weapons that are more precise, military decisions can be better informed, and military aims can be achieved without the need for kinetic force or physical destruction. But at the same time, we have to recognise that these technologies can pose new risks to combatants and civilians, and they are challenging the interpretation and implementation of IHL. So I'll just move on to cyber first of all. So the use of cyber operations during armed conflict, it's already a reality. Even though only a few states have publicly acknowledged using these operations, but a growing number are developing military cyber capabilities, and this use is only likely to increase. So I've got here on the slide the definition that the ICRC uses in terms of understanding cyber warfare, operations against a computer system, through a data stream, and when used as a means or methods of warfare in the context of armed conflict. And this is important because we often see the word cyber attack, the word cyber warfare thrown around a lot, when really what they're talking about are hacks or perhaps disinformation or misinformation campaigns that are not in the context of armed conflict. And we know, of course, that means IHL doesn't apply. But if we're looking at ones in the context of armed conflict where IHL does apply, there are questions about how certain provisions apply and whether IHL is actually adequate. So for instance, IHL already does provide strong protections. You have the obligation for parties to respect and protect medical facilities and personnel. And so any cyber attacks against the healthcare sector during armed conflict would certainly violate IHL. And, you know, more generally, IHL prohibits cyber attacks against civilian infrastructure. It prohibits indiscriminate or disproportionate attacks. So if you have a cyber attack that can't be controlled, or even if infrastructure or parts of it, like a specific part of a power grid, for instance, even if that was a military objective, only that part can be attacked. So your cyber weapon needs to be capable of discriminating, essentially. But there are other IHL concepts that are less clear when it comes to cyber. So for example, what about data? Is data an object? We talk in IHL about protections for civilian objects. Is civilian data a civilian object? In the ICRC's view, it should be, because if you think about it, it would be quite odd if paper files that contained essential civilian data were protected and you couldn't destroy those, but digital files weren't. And I think surely the consequences are the same. And in a world where data is increasingly essential as a component of digital life and identity, this is a question that states will need to answer. Here in the Philippines, I've been struck by, and I think I saw a statistic about the Philippines being the biggest per capita user of Facebook. So, I mean, if you were to shut down and remove the data that people have online, I think this would be fairly catastrophic for many people's lives who rely on this every day. Then you have a question about a cyber operation without kinetic consequences. So one that only occurs in the digital domain. Can that ever constitute an attack? Because the reason this is important is the IHL requirements to distinguish and for attacks to be proportionate. They only apply if something is an attack. And in IHL, an attack is defined. It's a term that's defined as an act of violence against the adversary carried out in offense or defense. Does this cover a cyber attack that has only digital and no kinetic effects? This is another question that states will need to grapple with. Then we have autonomous weapons, and I think this term often conjures up very futuristic images of Terminators and what some people call killer robots. But of course, the reality is that there are already many autonomous weapons in existence. There are weapons like this that are deployed. So you might have incoming missile defense systems on warships, perimeter defense systems, where they are programmed if something comes into airspace to respond. Things like loitering munitions, both on land and at sea. Even a landmine can be considered a very basic autonomous weapon. But the real risks that we talk about from a humanitarian and from an IHL perspective come when we think about some of the potential extensions into autonomous weapons that attack a wider range of targets over greater areas, over longer timeframes, in complex environments like the urban settings we were talking about earlier. And the difficulty here is that many of the assessments and the decisions that are needed by IHL, they require context-specific judgments. Things like a proportionality or a collateral damage assessment, they need to be done in the context of the prevailing circumstances at the time. The commander always needs to look at what are the facts on the ground. And this is where autonomous weapons fall down. They can't understand context. They don't have an ability to understand background. So for instance, how could an autonomous weapon spare injured soldiers when there's no human there to recognize that those soldiers are hors de combat? And this has led the ICRC to conclude that we really need international limits agreed by states. We need legally binding new rules to regulate autonomous weapons. And this should both clarify how existing international law applies, but also supplement that legal framework where there are gaps. So moving on, another key feature that I'm sure we're all very familiar with of contemporary conflicts over the last decade, it's the huge proliferation, the huge growth in non-state armed groups. So in some of the more complex recent conflicts, analysts have said that there have been hundreds, if not thousands, of different armed groups engaging in violence. And these groups have widely varying characteristics in terms of their size, their structure, their capabilities, and also just their motivation for violence. It's more and more blurred between political motivation, religious and criminal, and it all makes it very difficult for humanitarian actors like the ICRC to operate safely and to engage effectively with all these different groups. It also poses challenges for the application of IHL, because how do we identify which particular armed group should be considered a party to the armed conflict and therefore bound by IHL? It's very important because that will determine what force can be used against them, what force can be used by them. It will also have implications if they're detained by state forces, because what regime are they detained under? So we have cases of alliances or coalitions of non-state groups that are all fighting against one enemy. And on their own, each of these groups might not be carrying out military operations that are very intense. So on their own, they might not trigger an armed conflict. But can we add that all up, and can we combine that intensity of the collective efforts and use that to satisfy the threshold that's required by IHL? We also have what are sometimes called splinter groups, where you have factions that split off and they form their own new command structures. So at what point should we consider them new groups that are party to the conflict? And these are questions that both the ICRC and states, and I would suggest that this has been a question that you have had to face here in the Philippines in an increasingly complex conflict theatre. So now finally, just turning to my last challenge, I wanted to flag climate and the natural environment and its interaction with IHL. So no surprises to any of us, I'm sure, but sadly, climate change, environmental degradation is affecting populations around the world. It threatens lives, it exacerbates existing tensions, vulnerabilities, inequality. And one of the saddest realities is that the people that are most affected by armed conflict also tend to be those that are then most vulnerable to the effects of climate change. This is not a coincidence, because, so as we discussed earlier in the context of urban warfare, armed conflict harms assets like infrastructure and institutions and livelihoods. And so the communities that are experiencing conflict become less and less resilient and less adaptable to climate change impacts. There's also another aspect about this, about the damage that's caused to the environment by war itself. I think the environment is very frequently one of the casualties of war. One of the classic examples was in the Vietnam War, where they had widespread use of Agent Orange, which destroyed whole forests. But this damage is not often that visible. It doesn't tend to be as apparent, and it doesn't tend to be a priority of the warring parties. And I think, again, a certain amount of environmental harm is inherent in armed conflict. It can't be avoided, but it can't be unlimited. There needs to be some regulation. And IHL, it doesn't address all environmental consequences of armed conflict, but it does contain rules that can protect the natural environment and that can seek to limit the damage that is caused to it. So in September last year, the ICRC released updated guidelines on the protection of the natural environment in armed conflict. And it's a very, I think it's a very easy to read document that sets out 32 existing rules and recommendations relating to the protection of natural environment under IHL. So it deals with tricky areas. For instance, under IHL, there's no agreed definition of natural environment. In fact, in international law generally, that's not an agreed term. So the guidelines look at the different ways that the term is used, and they come up with a definition covering the very intricate and interconnected system between living organisms and their habitat. And then the guidelines consider questions like, is the natural environment a civilian object? And if it is, how does that affect principles like distinction, proportionality, precautions in attack? So I think they cover very fascinating ground, but of course I'm probably a bit biased. But the idea is that the text is meant to be understandable. It's meant to be able to be incorporated into, in particular, military manuals, but also national policy and legislative frameworks. And so that's our next step, is working with states, working with armed forces such as the AFP to do that and make sure that we're really ensuring the best protection possible for something that is crucial to all of our survival. So that brings me to the end. I'll stop sharing there. I would be very happy to take questions either on what I've spoken about or of course on any other aspect of the ICRC's engagement in IHL. So thank you. Back over to you, Lieutenant Colonel Esquivius.
Thank you very much, Ms. Georgia Hines. Are there any questions, or can we proceed with our second speaker so that we can have the open forum later? Yeah. Well, our second speaker is Mr. Ricardo Lucero Jr. And he is the Armed Forces Delegate of the International Committee of the Red Cross in the Philippines. Being the Armed Forces Delegate, Ricardo advises and supports the delegation in its dialogue with the AFP, the PNP, and non-state armed groups. He develops and maintains contacts with authorities or other interlocutors at various levels, and supports the delegation's efforts to integrate IHL, or International Human Rights Law, into relevant aspects of AFP operations, military, and police academic programs. Ricardo has been with the ICRC since October 2017. Prior to the ICRC, he was an active member of the Philippine Army who worked and had solid work experience in combat operations from various levels of command within the AFP. He has a heavy background as staff officer in operations, plans, international defense, and security arrangements, and peacekeeping operations. He has related experiences in training on resource management, military ceremonies and protocol, force integration of indigenous and former rebels into the AFP, and project management under the Philippine Defense Reform and the Philippine Army and the AFP Transformation Roadmap. He graduated from the following major courses. First, from the Philippine Military Academy in 1994, the Command and General Staff course in Command and General Staff College in 2015. He has a master's in public management major in development security in 2015 with the Development Academy of the Philippines, and the Nalsar University in India in 2017 on postgraduate diploma on IHL. He has taken also courses while at the ICRC, like the induction training on for the Armed Forces Delegate, the Law of Armed Conflict at Sea workshop in Shanghai, China, the FAST PG induction training in Geneva, and the senior workshop for international rules governing military operations in Suirmo. Ladies and gentlemen, it's my honor to present to you our next speaker, Mr. Ricardo Lucero Jr. Sir?
Thank you, Ed. Good afternoon, sirs. Please allow me to share my screen. Okay, is it showing now, sirs? Kindly acknowledge.
Yes, sir. We can see it, sir.
Yeah, thank you, sir. Thank you for the AFP Center for Law of Armed Conflict and the Philippine Military Academy Alumni Association for this rare opportunity. As mentioned, I'm Cavalry Ricardo M. Lucero Jr., a proud member of PMA Class 94. I'm the Armed Forces Delegate of the International Committee of the Red Cross here in the Philippines. So my presentation, sir, will talk about the international humanitarian law in the Philippine context, because most of us thinks that IHL does not apply. IHL is foreign. IHL is not Philippines. IHL is something that is alien. But in truth and in fact, IHL is what we have and what we are experiencing now. So going back to the let me take you back to public international law, because this is where IHL and the very famous or not so famous international human rights law for most of those that are serving still in the military. So you can see that these two bodies of public international law are the ones that focuses on the use of force. So IHL is or the jus in bello, or rules in the war, and IHRL, which speaks about the right to war. Basically, these are two different things, but most of us, even I myself before, did not realize that these are very two different entities of law, two bodies of law that are different from each other. So taking into consideration what they are, so you can see that basically IHL does not prohibit us from fighting. IHL is a law that ensures that we use the right means and methods of warfare. However, international human rights law is the one that prevents us from fighting unless we fight collectively or unless we fight in self-defense. So what are the sources for IHL? IHL is based on the Geneva Convention. Its additional protocols and the more than 30 treaties and legal instruments that we have, and customary international law that has dated way back even before our contemporary IHL has been on. And why is it important for us, the relevance of IHL in our country? First and foremost, some of us may not realize that yes, it is something that is foreign. However, we have treaty obligation. Way back when we were in J5, we were thinking of our engagements. We were thinking of our bilateral and multilateral engagements, our obligations. But we did not realize that we have more robust and more important aspect of an obligation that is our treaty obligations. And one of them is our treaty obligations when our president, the then President Manuel Rojas signed in 1952 the Geneva Convention. And the first common article of which says that as high contracting party we were and we are, we must undertake to respect and ensure respect for the convention or for the international humanitarian law, the Geneva Convention, which is basis for international humanitarian law. And why is it relevant in our country? Because practically we are in a conflict situation. As far as we assess it, we have 6 non-international armed conflict in our midst, in our country. Most of them are protracted, one against the communists, and the others are against various armed Muslim secessionists, so-called uh, groups, terrorist groups, quote unquote, and other groups that are claiming Daesh or Caliphate State of Muslim Caliphate State in Mindanao. So we have 6 non-international armed conflict. How do we assess it? First is in its organization. They are organized. They have leadership. They are armed. And next is that there there uh, there is intensity in the conflict. Why is it that MNLF and MILF is still there? Of course, we are reassessing it. However, as far as we are concerned, MNLF and MILF are still organized. There had been no DDR component yet in final peace agreements between them. So basically, they are still there. If we see that there's no longer organization, then we can remove them. Another relevant thing is that since we are in a conflict situation, we have 6 non-international armed conflict. The common Article 3 of the Geneva Conventions applies. So what's common Article 3? Most of us, especially when we are in the service, think that when IHL applies, it automatically accepts that there is belligerency on parties to conflict. However, it is explicit in the common Article 3 that first and foremost, each party shall be bound to apply that persons who are not or no longer taking part in hostilities will be treated humanely. And second is that the wounded and the sick shall be collected and cared for. Our fear for the application of IHL is that there can be special agreements that can be possible to uh, to enforce the law and to ensure that uh, the provisions of it will be applied by both parties. And second is that the application does not affect the legal status of the parties. So if, for example, IHL applies, it does not in any way automatically accept belligerency on any of the parties that we are or you are in non-international armed conflict with. Why? Because it does not, and it was specified in the Third Geneva Convention, that the application of such will not in any way affect the legal status of the parties to the conflict. Lastly, why are we here? Why is RCSC here? Because as far as the Third Geneva Convention is concerned, the convention that was signed in 1952, that an impartial organization or body such as the ICRC may offer its services to the parties to conflict. So we are here to offer our services. ICRC is here to offer its services to the parties, not only to the armed forces, but also to the non-state armed group if needed be. It is relevant to a country because amongst the several countries that signed the Geneva Convention, why we are one of the countries that have an implementing legislation to the Geneva Convention. For Geneva Convention, it's three additional protocols and customary international law. We have the Republic Act 9851. We have this since 2009, but unfortunately, this, despite the 6 non-international armed conflict we have, despite the several killings, despite the several violent actions between all parties to conflict, only one has been convicted of it. And the conviction is due to Marawi siege. So I think more still needs to be done. And I think the AFP is not working on it. So it defines and penalizes war crime, genocide, and other crimes against humanity. And it applies to all individual perpetrators, whether state agents or non-state armed group. As you can see, international humanitarian law, the Republic of 9851, the local legislation that we have, levels the playing field. What I means to say, when I say that it levels the playing field, unlike international human rights law, in which only state actors are responsible to follow it and can be sued if they are not able to do a function or task in ensuring that the laws are being followed, IHL applies to all parties to conflict, both the AFP and the non-state armed group. Another enabling law that we have is the Republic Act 10530, which is the Red Cross and Other Emblems Act. So you can see before even security guards wear red crosses in their medical aid patch. So now, because of this 10530, it has defined the proper use of emblem both to identify those that are authorized to wear it and to ensure that those that are wearing it or those objects that are sporting it are protected during armed conflict. It's for protection. And for the Philippines, we have accepted and based on the 10530, the use of the Red Cross emblem is being propagated. So most or all of the medical transport, all of the medical personnel, they are supposed to be having or wearing, sporting these Red Cross emblems when they do their tasks and they do their duties. Another very good enabling law that we have is the Special Protection of Children's Situations, or CISAC law. So it was enacted in 2019. It ensures protection of children in conflict situation or situations of armed conflict. Appreciating the need for special protection of these children, then our government and through our legislators, they have enacted this law. Another reason why IHL is very relevant to us is because with these violations, or we were victims because of IHL violations. It started years back during the time of revolutionary period. This is a picture of Budaho massacre. During World War II, during Japanese occupation, the Philippines was a victim of violations of IHL. During liberation, We were the second most bombed city all over the world. Imagine if IHL had been applied then. And recently, one of our cities has been destroyed because of IHL or its violations or the use of means and methods of warfare that are not so much of accepted. So it is not fault of anyone, but as George has been mentioning, if you use a protected object for military purpose, it becomes a military objective. So that's it. So for IHL and ICRC, so IHL or ICRC has been mentioned in the Geneva Convention for several times. No? So it is signed in the 1949 Geneva Convention in additional protocol and the statutes for our international Red Cross and Red Crescent movements. This is the mandate to ensure the protection and assistance of the victim, to promote the work of the faith and for the faithful application of IHL, and to serve as neutral intermediary between parties to armed conflicts. IHL or ICRC, you would think we are not an NGO. We are, at some point, can be considered as international or intergovernmental organization. We can be at some point considered as international organization, but we are like ICRC is sui generis. It has special purpose. It has special reason why it was established. And we are not part of the UN. We are not, most importantly, a human rights organization. We are a private association. We had been granted observer status, and we do not judge, we do not arbitrate, we have no, we do not prosecute, we have no prosecutory powers, we do not prosecute any allegation of violations. We are there to protect the victims of conflict. That is what ICRC is. In the Philippines, since 1985, we forged a headquarters agreement with the Philippine government through the Ministry of National Defense before, and we are considered as one of the diplomatic missions here. So our vehicles support diplomatic plates. And based on the Republic Act 11479, this Anti-Terrorism Act, we are also, based on Section 13, granted humanitarian exemption clause. It's very important for us because ICRC works in conflict-affected areas, protects and assists populace there, and with that protection and assistance comes sometimes questions on we or if we are protecting, assisting members of the considered terrorist organization. Because of this Humanitarian Exemption Act for Republic Act 11479, we can say that the Philippine government acknowledges that there is such a neutral organization that works in conflict situation, and within the ambit of what is proper and what is neutral, it can do its task in the situation of armed conflict within the Philippine jurisdiction. So what are our activities now? We have for our part for the forces, armies, the security. We work with the armed forces and the national police. For the armed forces of the Philippines, we have two formalized partnerships starting 2020. prior years, we have several engagement with the armed forces, but seeing that we need to have formalized agreement, we forged terms of reference for in 2020 for the meetings. We put a structure so that these meetings can be done. We put a structure, a facility, so that technical working groups on various issues surrounding questions of international humanitarian law, a possibility of providing support to some actions relative to conduct of hostilities in the field, and some other relevant uh, studies on management of the dead, for example, on protection of healthcare workers and facilities, on integration of the IHL into the systems and process of AFP. Then that is what we are doing for that. And in 2021, in April, we also forged a memorandum of understanding, the AFP ICRC memorandum of understanding, creating with aspiration of integrating international humanitarian law, the systems and processes of the armed forces. Yes, we say that, okay, the systems and processes, or IHL, is integrated already to the processes of the AFP, because in our coordinating instruction we placed that troops should follow IHL, respect IHL, rule of law, and IHRL. No, it's deeper than that. It should be that even if it is not placed in the coordinating instruction, troops, starting from planning, shaping, up to the execution of operation, should be able to know what are applicable, the means and methods of warfare, in ensuring that IHL is being followed. Then, project management for the memorandum of local workshops and seminars. Yearly, we have top level seminars involving leadership, the AFP, together with the PNP at some point. We have working group meetings, IHL trainings and lectures. If there are requirements, of course, there can be some requests coming, especially from Center for Law of Armed Conflict, and trainers training. You also provide trainers training for the trainers of the major services and all relevant commands and units of the armed forces. Regional workshops and seminars, we send, especially during the time when restrictions are still not on, and we still can send uh, personnel abroad. We send personnel from the AFP to various seminars abroad, not only the region, Southeast Asia, but also to Europe, and at some point, some other regions in the other continents of the world. For the PNP activities, we also have a formalized partnership with them in October 2020. We had an MOU to develop the capacity of the key police officers in their understanding for IHRL, the basic principle of the use of force and firearms, as well as the program for international humanitarian law. We see that one of the reasons why there are no convictions of IHL, why there are no cases that are filed against perpetrators or alleged violators of IHL, because starting from investigation, IHL is not appreciated. So if it's not appreciated from start of the process of prosecution, then regardless of the numbers of IHL laws that we have, we can never have conviction. As public international law, it is the only law, or it is the only uh, uh, It is the only area within which we can remind or we can tell all peoples in the world that yes, some of these guys that they are cuddling are really terrorists or really uh, violators of international humanitarian law and one of the branches of public international law. Then local workshops and seminars. We have workshop top level seminars also with the police. We have working group meetings on the IHL doctrines. We have trainees and lectures, trainees of trainers, and regional workshop. We also send them to SWIRPO for this year. I think it will not push through because of some restrictions. Maritime security operations, and the latest that we have, but it was postponed, is security sector on COVID-19 lessons identified. That ends my briefing, sir. I'm now ready for questions.
The floor is now open for questions, sirs, ma'am. You may use the raise hand function if you want to talk, or you can use the question and answer function seen at the user interface.
So I can see there's a question in the chat about ICRC being aligned to Amnesty. I would be happy to.
Hello. There's a
Sorry,
phone-in
ma'am,
question here, Georgia. They texted me actually. Where do we file cases for IHL abroad?
Where do you file cases for IHL abroad? I wonder if they mean for IHL violations committed outside of the Philippines.
I would say violations committed by non-state actors in the Philippines. The question is, where can they file?
Oh, okay. I mean, so as Ricardo was talking, we have in the Philippines Republic Act 9851 that essentially makes IHL violations into domestic criminal offences. And so then a crime against that act follows the same process as any other crime in the Philippines. And this has to be brought by the prosecution service. So we do a lot of work with the Department of Justice, with their National Prosecution Service, to ensure that prosecutors have full knowledge of the Republic Act, and they can work with police investigators and potentially AFP investigators as well. But I mean, like any other criminal law, it is not a civil action that could be filed by a civilian. It needs to go through police and then be brought to the prosecutors, who make the determination as to whether there is sufficient evidence to proceed with the prosecution. I hope that helps. Yes. I might add as well that in the Philippines, there is an interesting mechanism and quite progressive, where a lot of the regional trial courts are designated as what's called IHL courts, and they're specifically mandated to hear IHL cases, so cases against RA 9851. So the idea is that they are staffed with judges and prosecutors who have an understanding of this law. And I think that's it's a really interesting and commendable step that the Philippines has taken. As Bong said, there has only been one conviction in those courts. There is another case pending.
Okay. The next question is, is Amnesty International aligned with ICRC? What's the connection, or do you have commonalities?
I can answer that one quite quickly, I think. So no, we're not aligned with Amnesty International. In fact, we're not aligned with any other organization. Having said that, I mean, we have good relations with Amnesty, but the key difference is along the lines of what Ricardo was saying. Amnesty International, their primary area of work is in relation to human rights. And they are an advocacy organization, so you see them a lot in the public space, and they have a very important role to play in that regard. The ICRC, it is in relation to international humanitarian law or law of armed conflict. So they are two separate areas of law. The other difference with the ICRC is that we have our mandate given to us by states. So our mandate is contained in the Geneva Conventions, in an international treaty. And that's why it's so unique, because it is actually governments who have said, ICRC, you have authority to work in armed conflicts. And the other interesting difference is that the way we work is confidential and bilateral. So that's why you don't often see us speaking out and speaking publicly. So often people will say, why haven't you done anything about this situation here? Or, you know, why haven't you spoken out about this violation there? But actually the way that we work is that all of it is done behind the scenes, and that's designed to ensure that we preserve trust and preserve our access on both sides of a party to the conflict. Because you can think about it, if we were to go to the media every time that we saw a violation, well, obviously parties to a conflict will stop talking to us, and they will stop allowing us access to the affected populations. And so we would be unable to complete our work.
Thank you very much for that answer, Georgia. There's another one here. Can you define or distinguish between human rights and humanitarian international humanitarian law?
Sure. Yeah, it's a really, really common confusion. And I can understand why. They sound almost the same, which is why sometimes it's better to use law of armed conflict rather than international humanitarian law. International human rights law is about the rights that are held by individuals, and they are enforceable against their government. So these are things you might have heard of, the UN Declaration on Human Rights. It's quite famous. So you will talk about the right to life, the right to, there are certain economic rights, the right to, say, be free from sexual slavery, or there are certain sort of fundamental rights. And these are the ones I think that people know, because they apply all the time. There doesn't need to be an armed conflict. They apply any time, whether it's peacetime, armed conflict, everyone is always entitled to their human rights. And there are mechanisms at the international level, so you can go to those as an individual to complain about a breach of your human rights, essentially. International humanitarian law is about the way that parties to an armed conflict are able to use force, and it contains certain protections for civilians, for medical personnel, for other categories of protected groups. So it's a slightly different concept, because they are not rights that are given to an individual. They are more actually limitations on the way that parties in an armed conflict can use force or can carry out warfare. They are also, so IHL applies not only to governments, as Ricardo was saying, it applies to non-state armed groups, it applies to anyone who is a party to an armed conflict, but it only applies in armed conflict. So human rights, all the time, enforceable by individuals against their governments. IHL, only in armed conflict, and it's about regulating the parties and their relations in armed conflict. I hope that helps, but it's a tricky area, so happy to clarify more if need be.
Okay. There's a chat here in the chat box. It says, can we file IHL case against a person by virtue of command responsibility? Example, can we file a case against Joma Season based on the IHL violations of the NPAs in the Philippines?
Yeah, so IHL does contain this notion of command responsibility, and it's fairly unique to IHL. So it's essentially, whereas in ordinary criminal law, you either have to directly do an act, or there is some provisions around you can aid or assist an act, for instance. But for IHL, you can have someone be liable for a violation by their subordinates if they are in either an official command position or a sort of de facto armed position. And you can think about, yes, with an armed group, they're less likely, well, in some cases, they're less likely to have clear ranks and formal documents setting out command structures, but they will have de facto command authority. So in those cases where that commander knew, or they should have known, about the actions of their subordinate in committing an IHL violation, then yes, they can be held responsible for the actions of their subordinate under that principle of command responsibility.
Yes, and I would like to reinforce that under RA 9851, it specifies that indeed the commanders can be held liable for as long as you have evidence that supports that the commander did not have any actions to prevent such violations. There's another question here. According to Sir Piquiras, probably this might have been discussed, but I just want to know how ICRC survives, or what is the source of fund of ICRC?
Yeah, very common question again. So ICRC is primarily funded by states, by governments. And I think this can be kind of challenging for some people, because they say, well, how can you be independent and how can you remain neutral if you're taking money from governments? But the way that we deal with that is we take the money and then we don't accept limitations on how we can spend that. So a government can't give us money and say, oh, but you can't use that to benefit this particular armed group, or you can't use that in this particular context. So that's how we maintain independence, and we are the ones that decide then, based on our neutrality and based on an assessment of where the humanitarian needs are, we decide how that will be spent globally. So essentially it kind of goes into a big pot, and then we break it up. It's not funded like the UN. So the UN has like a scale of contributions from each country. The ICRC is actually voluntary contributions by states. And so, you know, you have some donors that give a lot more than others. And I mean, that's entirely their prerogative. So if they're not happy with where we're spending our funds, they don't have to fund us the next year. So that is the bulk of our funds. We also receive a little bit from sort of private actors and private partnerships, but it's very small in comparison. The vast majority is from countries.
All right. There's an interesting question here. Georgia, how is the Philippines viewed by the ICRC and international community in the Philippines on the Philippines' compliance on IHL as compared to other countries in Southeast Asia or in the Asia-Pacific region?
Good question. So, I mean, one thing that we often say about the Philippines when we are in trainings or lectures or whatever is that the Philippines has a very progressive and a fairly comprehensive legal framework to implement IHL. And so actually many other countries in the region do look to the Philippines as an example. So we spoke about Republic Act 9851 already. This is the IHL Act, which contains a really good list of war crimes and other crimes that implement those IHL violations. But then Ricardo also touched on there is the law protecting the emblem that's required under IHL, so that's positive. But then there are ones that go even further, ones that I've not seen in other countries that I've worked in or covered. And one of those is the law on the children in situations of armed conflict law, because one thing that does that's commendable even in itself is set the age for children at 18. And actually under IHL, there's a bit of disagreement. Is it 15? Is it 18? To set it at 18 is really good because that's really protective. It means that everyone up to 18 is considered a child. And under that law, it says that children are primarily victims. So they can't be held liable for violations of IHL because they are victims. Often they do not have the mental capacity. They are often recruited when they are young, and it recognizes that they actually need assistance. There are a few exceptions to that. So they can be held liable, for instance, for certain violations against other children, but primarily it focuses on a rehabilitative model for children rather than punishing them for things that were really not within their mental capacity. So I think that is a really good example and one that we often hold up elsewhere. As I said, the initiative of creating IHL courts is also a really good one and not one that I've seen in other countries around the region. And I mean, beyond that, I would sort of say my general impression is that the AFP also incorporates already a level of IHL training into their curricula, and the things like the Memorandum of Understanding that Ricardo highlighted between the ICRC and the AFP that will integrate IHL better into AFP doctrine, into training, into TTPs. I think these kinds of initiatives are fairly leading practice in the region. So, I mean, I could go on listing initiatives. There's the IHL Ad Hoc Committee, which is an interagency committee that deals with IHL questions, and it runs different initiatives every year in August, which is IHL month. So even just these kind of dissemination or these promotion mechanisms that you have in the Philippines are fairly unique and are things that we often in the ICRC use the Philippines as a good example.
Okay. Yes, let's continue with the Q&A, and there's seemingly related questions here. Says here, IHL only applies to, maybe he's asking if it applies only to state actors. Please clarify. Unfortunately, many might have not been familiar with this. And there's a related question, it says, just for clarification, ma'am, CPP-NPA is an organization declared as terrorist in the Philippines or in the Philippine law. When ICRC helped them, like to extricate wounded NPAs after an encounter, where would that put the ICRC in our Philippine laws?
Two good questions. So the first one I think is fairly easy. IHL doesn't just apply to state actors, it applies also to non-state actors. It applies to anyone who can be considered a party to an armed conflict. And in fact, in most armed conflicts, as I was saying, there's now many non-state armed group actors. And I would say that's the predominant form of conflict rather than what we used to see with world wars, for instance, where you only had state on state. On the second question, I should say firstly that in IHL, there is no concept of a terrorist organization. So IHL is neutral about that kind of designation. What it says, it has criteria that you apply to determine whether a group is an organized armed group for the purposes of IHL, and that's one of the tests for them to be a party to an armed conflict. So for them to be bound by IHL, they have to meet certain criteria, but those criteria don't include, say, whether a state has designated them as a terrorist organization. That is not something we look at. So things around counterterrorism legislation and states are perfectly entitled to take measures to protect their national security, and many do so, including the Philippines, of course, with the Anti-Terrorism Act. But they need to be consistent with IHL, but they are not the same as IHL. Now, when we talk about ICRC's interactions with groups that have been declared terrorist organizations, whether it's here or in many of the other countries we operate, the way that we deal with this is we, under international law, have a mandate essentially to engage with these groups. That's exactly what states have told us to do in the Geneva Conventions. And so we need to have domestic law exemptions from counterterrorism provisions. And that has been enacted in the Philippines. So again, leading practice. When the Anti-Terrorism Act was going through, there is an offence in there about providing material support to terrorists or terrorist organisations. Now, if there were no exemption, then yes, any support we provide to those parties in line with our humanitarian mandate, whether it be required evacuations, whether it even be training, first aid training, or training on IHL, which is something that is necessary on both sides because they need to understand their obligations as much as the armed forces do. But that would obviously be criminalized under anti-terrorism legislation. So we have an exemption under Section 13 of the Anti-Terrorism Act that says that the humanitarian activities of the ICRC, but also of the Philippines Red Cross and of any other humanitarian actors that are authorized by the state, they do not fall within that offence under the Anti-Terrorism Act. So hopefully that clarifies.
Yeah, that was a wonderful answer from you, Georgia. There's another
Can I add one thing, sir? Yeah, sir.
Yes. Okay.
Yes, sir.
Can you add to that?
For the question on is the Philippine when ICRC help them extricate wounded? First, we don't extricate wounded in the battlefield while battle is ongoing. We are not capable. We are not bulletproof, and we also, of course, protect our staff. We do not do that. Next is we only evacuate wounded who are not and no longer capable of fighting. Those who want to escape from military operations, they are not the ones that we are referring to, not capable and no longer fighting. So we assess if he is really not capable and no longer fighting. And the third one is they should not be armed. If somebody escorts him, the escort should not be armed as much as possible. He should not be escorted. We coordinate with all parties to the conflict that we evacuate or conduct medical evacuation from point A to point B. And if one of the parties to the conflict does not approve of our working modality, then we will not do it. The next one is we also tell the person who will be evacuated that we could not guarantee that he will not be facing prosecution once he goes down and after he has been treated to the hospital that is of choice of the ICRC. So first, we do not extricate wounded in the field. We are not emergency medical facility. Second, we only come in if there had already been no conflict, no fighting. Third is that we can only come in if our working modality is accepted by all parties to the conflict. The last one, we will not guarantee that the state forces, for example, if he is a member of the non-state armed group, will not be able to apprehend him, put him to jail for all the things that he has done. So that's it on the question on helping or extricating of some sort those wounded in the field.
Okay, since you're online already, Rick, can you answer this one? May you share with us the current state of IHL trainings conducted to the Philippine judges and prosecutors by the ICRC? Based on RA 9851, judges, prosecutors should receive sufficient trainings on IHL. These are judges now who can be said that the majority of them already underwent training.
It is under Georgia's file. I think Georgia will be better off to answer the question.
Sure. Thanks, Ricardo. Yes, so my department, the legal department, actually does work with the Philippines Judicial Academy to conduct training for judges and for prosecutors through the Department of Justice National Prosecution Service. So for judges, for instance, we ran a training of trainers earlier this year, and we had about 25 judges from the regional trial courts go through that, and it was about a 5-day intensive program for them to essentially brush up on IHL. They ran through various case studies, and the idea is that then they are trainers who can, within PhilJA, within the Philippines Judicial Academy, spread that knowledge further. And so we're already seeing next week we'll be running another training with the Supreme Court attorneys, and we're using some of those judges as trainers for IHL as well. So, I mean, this is just one of our more recent initiatives. We have, we've drafted a manual for the judiciary, so like a bench book on IHL that they can use as a reference document. And we've been running these kinds of trainings for years. They were previously called multi-sectoral training and included not only judges, but in that same breath, they had prosecutors, they had the PNP as well. Now we sort of tend to do them separately because they have slightly different considerations. For the prosecutors, we ran a course late last year and then another one 2 weeks ago that was led by the Department of Justice. Again, it's about a 5-day program, a training of trainers on IHL. So that's something that we want to see continue. So I would say actually the capacity is probably already fairly high when you look at other countries where I would say the judiciary is not so familiar with IHL. And that's because, as Ricardo was saying, it's relevant in the Philippines. You have a domestic act, and there are ongoing non-international armed conflicts, unfortunately. So I think it's fair to say we will see cases that judges and prosecutors need to be familiar with this body of law.
Okay. Yes, and in addition, by the way, let me announce that the Department of Justice just recently launched the 2021 series of trainings that will be conducted. This is a joint training for IHL, for the prosecutors, police, and the AFP. So we will benefit from it. Now, let me proceed with the Q&A box. There are some good questions here. Ma'am, does ICRC have a proactive measure rather than reactive during conflicts or in between conflicts?
Good question. So it depends what is meant by proactive. One thing I should say we don't do is we don't get involved in trying to promote peace or promote sort of peace negotiations. As Ricardo was making that distinction, there is a different body of law, UN law or use of force law, that talks about whether parties can go to war, whether they're entitled to do that and use force against another state. We don't get involved in that. We are neutral and we stay neutral. What we do though is preventative work in advance to build the legal frameworks, build the capacity within countries, the understanding, and also within communities, their resilience, so that if, unfortunately, we have armed conflict, at least we can have armed conflict where the parties understand and respect their obligations, where communities understand their protections, and where you have appropriate legal, but also the infrastructure mechanism. So even things like trying to remove military objectives from within civilian infrastructure, making sure that we reduce those risks to a civilian population. So that's what we call our prevention work. It's not about preventing war, it's about preventing the effects of war on civilians and civilian populations.
There's a very good question here. If I'm a civilian, can I lose my immunity as a non-military target? And another one, can ICRC evacuate wounded combatants who are considered terrorists as declared by international community?
Okay, so the first one about civilians losing protection. Yes, civilians, they are protected, but yes, they can lose that protection. The way that they can lose that protection is when they, what we call, directly participate in hostilities. So that's, I mean, it can be something as obvious as picking up a weapon and firing at, the enemy. Obviously, then they become involved in the hostilities and they are targetable. However, they are only targetable for the duration of that act. So once they cease those activities and go back to their civilian lives, then they cease to be targetable. They are once again civilians. This is slightly different than, for instance, well, you all as military members, you are targetable all the time because you are part of the armed forces. So even if you are not doing something that is at that moment directly participating in hostilities, even if you are sleeping, you are still targetable. That's the difference with civilians. And it doesn't have to, I mean, I've given the example of an easy one of shooting at an enemy, but direct participation can take many forms. So it can actually be something like providing intelligence to one side to a conflict, but it needs to be specific intelligence for a specific operation. So they need to know that they're assisting a specific act that will weaken the enemy. Providing sort of general situational awareness, like, oh, yes, an armed group tends to come through here. That's not going to be sufficient to constitute direct participation. So there's a few tests in there, and it's a bit of a case by case, but there are actually criteria in IHL that set out that aspect. Now, on the second question about evacuating wounded, I think Ricardo's probably covered it fairly well, but I would again emphasize that IHL is not concerned with designations as terrorists. IHL is only concerned with, is the person what they say, are they wounded, are they sick, and are they out of the fight or hors de combat? And if they are, then part of our humanitarian mandate is to provide them with assistance, because they become a protected category. So they can't be attacked, and we have a mandate to provide them with humanitarian assistance, whether that be medical care or other things. But it's not affected by whether they are designated as a terrorist.
Okay, let me just read some related questions here to the previous questions. Although this has been answered, but we can have a quick reply to this. Who will prosecute individuals, those individuals responsible for violating the IHL, and where will it be prosecuted? That was answered a while ago, but just a quick reply later. And then there's another one here. Can you be invited, being an ICRC personnel, can you be invited to be a witness to an IHL case?
All right, so these are great questions. I love it. The first question about, I think, as you said, we've covered it fairly well about who can prosecute. Same as any crime, it is the police that end up as the investigators, and it is the prosecutors, the National Prosecution Service, that are vested with that responsibility to determine whether a case brief meets the required threshold, and to, if so, to bring a prosecution before the courts. On the second question about ICRC being called as witnesses. So under international law, but also under domestic law, we are actually protected, or we have what is called privileges and immunities that mean that we can't be called to testify as witnesses. And this is, again, because of that confidential way that we work, the international community has recognized that we need to have a level of protection, because we need to be able to continue our mandate. And if a state party could call us before a court and essentially compel us to testify against, say, a non-state armed group, well, we would never be able to gain the trust of that non-state armed group, and it would put our delegates in danger. So in the Philippines, we have a headquarters agreement, and in that headquarters agreement, it explicitly says that we are exempt from providing that kind of testimony in a court. Now, that is not, it's only related to our official functions. So say we have an ICRC delegate who goes out, has a wild night and commits a crime that's not related to his or her functions, they can absolutely be brought before domestic legal processes. So it's similar to like a diplomatic immunity. It's only in relation to our official functions. And so it's designed to further our mandate. It's not designed to protect us and to put us above the law as individuals. We are still bound by domestic law, and we, in our headquarters agreement, actually agree to comply with Philippines domestic law.
Okay, that was a wonderful answer from you, Georgia. Let me direct this next question to Ricardo. I know he's more familiar with the local situation. Regarding CAFGO, this is the civilian active auxiliary. If they are not on duty, do they be called non-military target?
So the question, yes, sir. Thank you, sir. Thank you for that question. We should establish the fact that what are these CAPGU if they are continuously doing combat function while they are appointed as CAPGU, or they are part-time soldier and part-time farmer, for example. Because the point is that first, I was force integration branch of J3 before, and I was looking at the document which says that CAFGU should, when he is not in his detachment, be considered a civilian, and it is not there. That is an example of a thing that should be integrated into the systems and process, because it had not been defined so, and it behoves upon us as well to tell our enemies, or those enemies, or your enemies, or the contending party, that these people are civilians when they are out of duty. However, internally, there can be problem on COA, on some issues regarding duty, the relationship of duty and, for example, that if it is line of duty, if he is home while not performing as CAFCO in a detachment. So most of the officers or those that are handling the CAFCO, they declare that he is on official duty or doing some intelligence job while he is home. That's why he is that is still in line of his duty, and he can get the remuneration which is due to him. However, we should be specific when we want that KAFGU who is not on duty should not be targeted by the enemies of or the non-state armed group. So, in short, if KAFGU is not a military target, it depends on you if you declare so. However, if a KAFGU does not pose any military threat to an attacking force, he should not be killed because there is no military necessity that should be applied when you kill a KAFGU, for example, who is not armed, who is just tending his field in the farm or doing his normal activities as a civilian. I hope it answered the question, sir.
Yes. Yes, I would like to take advantage of the presence of most of the attendees here are the different human rights officers of and IHL officers of the AFP, and they would like, of course, to be clarified. There are cases that involves some soldiers who are on civilian attire who went on marketing or want to buy some foods in the food in the market, and then they got ambushed. Likewise, there are also police officers, though in uniform, they are considered civilians. They are not military, but still they are ambushed by the CPP, NP, NDF, or whoever is the non-state actor involved. So what can you say about this, Bo?
Sir, there are three principles: distinction, proportionality, and precaution. However, those three principles are established on the foundation of military necessity as well and humanity. So, if, for example, a soldier, what is his status? Is he a civilian or a state actor? Yes, he is a state actor. Before you can target him, the question is if targeting him would entail military necessity. Is it necessary? Will you gain military advantage if you are going to take him down? Is he posing threat on you? So if he is not, should you kill him? That's the question. The same way that if you see an NPA outside, for example, in the Congress, you see them. Are you going to kill him because he is an NPA? No. You are going to arrest him or do some other means that may not entail killing him because that is not necessarily possible and not military necessity. There's no military necessity of doing it. And humanely, it's not possible. I hope it answered the question, sir.
Yeah, very good answer to the question, Ricardo. Now let me ask the last question to Georgia. This is from my classmate Rocky Binag. How do ICRC handle if you have an ICRC personnel casualty, meaning maybe he's a casualty in the performance of your ICRC mandate?
Yeah, I mean, this is a sad reality because I think Ricardo's already mentioned, we don't carry weapons. Our personnel, we don't accept armed escorts. And so you can imagine, I mean, we're operating in very difficult and very dangerous conflicts. And we're relying on what we call perception-based security. So we're relying on people seeing and respecting our mandate and our neutrality, which is why, you know, it's so important that we maintain that neutrality and that trust. But it's not foolproof. We do occasionally have casualties in the field. We currently have a colleague who is still missing, who was kidnapped in Somalia. we have had casualties in Syria, for instance. But what I would say is that these are fortunately the exception. So on the whole, our delegates are able to operate in very dangerous areas. Actually, the organisation that bears the biggest cost are the national Red Cross societies. So for instance, the Syrian Arab Red Crescent, they have lost, in 1 year, I think they lost close to 60 volunteers, which is just devastating. And I think, you know, maybe it's because they are often locals, and so they are caught up in maybe ethnic tensions. It's hard to say. But I suppose, how do we deal with it? I mean, we try to just avoid it in the first place. So we try to get security guarantees wherever we're working. We go through very rigorous processes to notify people, so the parties that have control over the areas that we operate in. So when we are conducting a distribution or an activity, we will tell whoever is either the government authority or the non-state armed group and get what we call security guarantees. In contexts where we can't get those security guarantees, we often don't go in. And I mean, this has been, especially in the Middle East, this has really hampered our efforts, because there are certain places where unfortunately we can't go. And I mean, it's not just us, it's most humanitarian organizations. I think we still have better access than many other organizations in places like Myanmar, for instance. We were the only organization in many areas providing assistance. When we are dealing with a colleague who has been kidnapped, often this is not related to the armed conflict. Often it's a criminal, sort of a monetary motivation, but I mean, the effect is the same. But we have like a whole negotiating team that works on that, who are trained in these matters. We will sometimes work with the country of origin, so the government of the nationality of whoever it is that is in that situation, because they will have their own diplomatic efforts as well. We do not pay ransoms, and I think this is an important policy, because, you know, we can't have people seeing us essentially as a money-making opportunity. If we're kidnapped, you know, we'll hand over cash. That's not a policy that we have, and with very good reason, as sad as it might be in individual cases. Hopefully that helps. It's not foolproof, but it works most of the time.
Yes. Before I let you go, Georgia, there's a follow-up question here, and I would like to facilitate it. ICRC can evacuate, or rather, if ICRC can evacuate wounded combatants who are considered as terrorists, can the state law enforcers implement arrests during the said evacuation, or may be allowed to take the custody of the wounded combatants and bring them to the nearest hospital?
Yeah, so this is a very common question. And as Ricardo was saying, nothing that we do is designed to allow combatants to evade lawful processes. So this is why we openly notify parties generally of our activities. And we are very clear with combatants, if we are evacuating them, to say, you know, you will be taken to potentially a state medical facility, and we can't guarantee that you won't be detained and prosecuted for instance, terrorism or firearms charges or whatever it might be. So, you know, they need to accept those conditions, and we are very clear that this is not a protective service. What we would say is that both parties to the conflict have an obligation to allow for the removal and the care of wounded combatants who are out of the fight. So no party to a conflict can impede the delivery of humanitarian assistance or medical care. So they need to allow whatever is the necessary medical care to be carried out. But after that has taken place, then by all means, law enforcement authorities can proceed with their domestic legitimate processes.
All right. So it has been a wonderful, fantastic, and lively exchanges this afternoon with our guest, Miss Georgia, and of course Ricardo. So we thank you very much, Georgia and Ricardo, for answering the very inquisitive queries of our audience. So
Thank you for having me.
I turn you over to the MC, Master of Ceremonies, Ed.
Thank you very much, sir. Thank you to Miss Georgia Hines and Mr. Ricardo Lucero Jr. At this point, may we request Captain Carbonell, Derek, to flash in the screen our appreciation.
Yes, sir.
Yes, our certificate of appreciation. We really learned a lot today, and we were enlightened on the ICRC workings in the Philippines, the work that they do, the IHL principles, the status of the Philippines in the international community, and we want to present this plaque of appreciation. We will deliver this to you, Miss Georgia Hines and Mr. Lucero. If I may read, the Philippine Military Academy Alumni Association Incorporated, the Philippine PMA Foundation for Truth and Justice Incorporated, and the AAP Center for Law of Armed Conflict present this plaque of appreciation and awards this to Miss Georgia Hines, the head of the Legal Department, International Committee of the Red Cross Philippines, for her enthusiastic participation as resource speaker in imparting her knowledge on the progression of IHL compliance with the ICRC in the international community in the Legal and Law of Armed Conflict webinar series, given virtually this 8th of June 2021 by Zoom webinar, signed Cavalier Ferdinand M. Bocobo, 1974, Director, PTJFI, Cavalier Joel S. Naknak, 1990, Director, AAP Center for Law of Armed Conflict, and Cavalier Amado T. Espino Jr., 1972, Chairman of the PMA Alumni Association Incorporated. Thank you, ma'am. And we also want to present the plaque of appreciation to Cavalier Ricardo Lucero Jr., 1994, for his participation as resource speaker in imparting his knowledge on the history and development of IHL in the Philippines, leading to RA 9851 in the Legal and Law of Armed Conflict webinar series, given virtually this 8th of June 2021 by Zoom webinar, signed by General Bocobo, 1974, Director PFTJI, Cavalier Joel Naknak, 1994, Director AAPCLOAC, and Cavalier Amado T. Espino Jr., 1972, Chairman PMAAI. Maraming salamat po.
Thank you, sir.
Now, we are about to end this webinar. It's a beautiful day outside, and we call on for the closing message, Lieutenant General Ferdinand Bocobo. Sir.
Good morning, everyone. Good morning to our resource persons, particularly Miss Georgia Hines and Cavalier Rick Lucero. Well, this is our second series of webinar, and I again thank our organizer, particularly Cavalier General Naknak, who took the lead in this continuing education for PMAers and non-PMAers alike. And so, short lang, I want to speak Tagalog, but Miss Georgia Hines could not understand. I'd like to again encourage our participants here. We are now 159. To continue this, we will have another one, which will be the last of the series. And so let us continue this one. We need this one at this time that there's a little heat in the political arena, you know, and so we need to continue to be updated of all the developments and additional knowledge so that we can perform our job truthfully, religiously, and without any reservation. All right. So again, thank you to our resource persons. We are very honored for you to join us here. Again, thank you, Ms. Georgia Hines and Cavalier Lucero. Good afternoon to everyone.
Thank you very much, Joe Bucabo, sir. Now we are now moving to the eagerly awaited part of our activity today, and that is the raffle draw. So, Captain Carbonell, please roll the wheel so that we will know who will be our winners today. Oh, our winner is from the 4th
4th
FABA
Field Artillery Battery from the
regiment.
Artillery Regiment.
Congratulations. Well, it's a surprise. Our prize for today is 1,000 pesos, and we will have 5 winners who will receive 1,000 pesos each. So congratulations to you. Now again, Captain Carbonell, please roll the wheel. For our second winner, the winner is Jufel J.R. Alasan, non-alumni. You can claim your prize from Captain Carbonell. So congratulations to you, Mr. Halasan. For our third winner, again, a non-alumni, Miss Chona Yabes. Congratulations to you, Miss Chona Yabes. Captain Carbonell. Our fourth winner is from Naval Forces Western Mindanao, NF7. Congratulations po sa inyong lahat na nanalo dyan sa NAV4WEM. And for the last one, Jennifer Kasidsid, non-alumni. Congratulations. You won 1,000 pesos from our sponsors, the PFTJI. And now at this juncture, we will now end our webinar for today. And we thank everyone who participated and attended this webinar. Please contact Ms. Chona Yabes for those who won the raffle, and Miss Isay with the numbers, kunan niyo po ng picture yan, the PTJFI Secretariat. And we hope to see you again at our next webinar on June 22. Our topic will be the Anti-Terrorism Act of 2020. Again, maraming pong salamat. Magandang hapon po. We now proceed pala as we close. Let us now listen and sing the alma mater, the PMA alma mater song. Maraming pong salamat.
Proud and
Thank you very much,
Thank you,
Cavalier
everyone.
Derek Corbonel. Thank you, sir.
Thank you, Ed. Thank you. Joel, thank you. Georgia and Bong, thank you.
Thank you very much, sir. Georgia, Bong, Ed,
Thank you, sir.
and Derek, and today's staff of PMAAAI-FPCLOAC. Thank you,
Okay.
sir.
See you again. Bye-bye. See you.
See you again on June 22. This ends our activity. Maraming salamat po. Magandang hapon po sa ating lahat.